All right, everybody, I think it's time to kick this off. Thank you all so much for being here. If you're trying to be at the Program in Criminal Justice Policy and Management of the Malcolm Weiner Center's Fall Speaker Series on pretrial myths in public safety, you're in the right place. I'm going to start just with some housekeeping. My name is Katie Naples-Mitchell. I'm the program director of that program here at the Weiner Center. And today's event, we are really lucky to be hosting Professor Andrew Manuel Crespo to talk about a recent paper he published on the possibility of collective action among accused people in criminal prosecutions. Before I give his bio, I just want to give some housekeeping about the overall speaker series this fall. Again, our focus was on the myths of public safety in the pretrial context. We've been kind of steadily marching through pretrial release and bail decision-making and reform to pretrial release and the pushback that reform efforts receive. In our last event, we talked about the right to counsel and whether people really have attorneys appointed, particularly in low-level misdemeanor cases in many jurisdictions. And today we're going to talk about the plea bargaining phase, and in particular, what happens in the whole scope of pretrial up until one's trial rights. To catch up with the rest of the speaker series and watch recordings of all of our past events, you can head to our website. The link is in the chat now. We post our videos on YouTube usually a couple of weeks, up to a month after, because our own Brian Welch logged on here, takes the careful work of making sure that the transcript is accurate for closed captions. And this is the last event in our fall series. We will be back next semester with a focus on parole and the myths of public safety in the parole and clemency context. So stay tuned for more information about that early next year. And now I think two other just logistical pieces. As you all heard, we are recording in progress, that we can post this video afterwards. So if you don't want to be on screen, please turn your camera off. And finally, we encourage and welcome participation throughout the event. So if you have questions at any point while Professor Crespo is speaking and while we're in dialogue together, please feel free to add a question in the chat, and then we'll call on you to ask it yourself or to raise your hand and be added to the queue. And again, there's no real waiting required. Please jump on as appropriate when your question arises. Okay, without further ado, I'd like to introduce Professor Crespo, who is the Morris Wasserstein Public Interest Professor of Law at Harvard Law School, where he teaches criminal law and procedure and serves as the Executive Faculty Director of the Institute to End Mass Incarceration. Professor Crespo's research and scholarly expertise center on the institutional design, legal frameworks, and power structures of the American penal system. Prior to his academic career, he served as a staff attorney with the Public Defender Service for the District of Columbia. He represented over 100 adults and juveniles charged with serious felonies, ranging from armed robbery to burglary to homicide. And as a member of Harvard Law School, he continues to be active in litigation, working with students to author merits and amicus briefs on various issues. Prior to law school, post-law school, he's also served as a law clerk to U.S. Judge Stephen Reinhart on the U.S. Court of Appeals for the Ninth Circuit, and then to Associate Justices Breyer and Kagan. We are so delighted to welcome Professor Crespo here today. Thank you so much for joining us. And with that introduction concluded, I'm going to turn over the floor to you.
Well, I'm just so delighted to be here with you, and want to thank you, Katie, and also Brian and Sandra for inviting me to be part of this terrific series, and to giving me this chance to just spend some time together with you and with everyone else on the Zoom, talking about an idea that I sort of reflected thinking, preparing, some remarks for today, that has been, I think, just bordering on an obsession of mine for what feels like close to half my life at this point. It's this, I think it grows out of, for me, a sort of pair of learning experiences I had when I was a student in college. I just wanted to sort of give that background to talk a bit about how I came to be sort of just so interested in this idea of the collective power of people facing prosecution. I think those two college experiences were these two classes that I took. One was taught by a man who still teaches here, whose name is Marshall Gans, who teaches at the Kennedy School, along with all of you guys at the HKS, and who teaches the theory and practice of community organizing. And I took a class with Marshall when I was a junior in college. And I think more than really any other class that I've taken in a few years of education, that class changed my outlook on some pretty fundamental things. It changed how I think about what makes a democracy a legitimate democracy. And it changed my understanding of what power is and where power comes from and the different types of power that can exist in a society, including the kind of top-down power that can be used by institutions, sometimes to help and sometimes to hurt, and the sort of bottom-up power that comes from the people themselves banding together and finding their own power in their collective agency and their collective action. The other class was a class that I took as an undergrad here by a man who, coincidentally enough, used to have this office that I'm sitting in here, whose name is Mort Horowitz, who taught legal history at the Harvard Law School, but also taught a class on the history of the Warren Court to undergrads. And it was the first legal class I ever took in my life. I took it as a college student here. And I was kind of captivated in the way that many liberals and progressives are when they first learn the history of the Warren Court and see a story of a court trying to use the law and the legal system to advance racial justice in society and to try to deal with some of the real problems of police power in the penal system. And that was the first time that I was really exposed to some of the intense harms that can come along with police power in the penal system. And it was also the first time I saw the idea of lawyers as both a potential source of that harm, depending on the actions they take in their career, and potentially as actors working to protect people from those harms. And the fascination with law kind of won out. I went to law school, and as you shared with everyone, Katie, I became a public defender as my first job, my first real job after law school. And I loved that job. I loved the people I worked with. I loved fighting on behalf of my clients and getting to really know them and know their families, to try to help them. I love the mission of the organization. But also the longer I worked there, the more I came to feel like there was a tension between that job, being a public defender, and some of the stuff that I had learned in my class with Marshall and learned about community organizing and the theory of power that underlies organizing. Because the very first article that Marshall assigns in that class is an article that the title of which is "Services Are Bad for People." The basic idea being that services make people dependent on the person giving them services, the service provider, and put the service provider as the one who has power that they're giving to the people receiving the services, as instead of relying on the people who are otherwise thought of as clients, as themselves a community with agency and power. So I don't know, services are bad for people is a tricky headline or mantra if you work in a legal services provider office. And when I was working as a public defender, I had this sense that there was in fact this sort of untapped power, the potential collective power of all of these individual clients, all of whom were going through things that were in many ways very similar. Not just the fact that they were being prosecuted, which of course was a common feature of all of them, but they were from the same communities. They were experiencing really common harms of the penal system, which is not surprising because it's a system and its harms are systemic harms. And the community of people walking through our office were the people bearing the brunt of those systemic harms. I just had this sort of sense of like, there's potential power here if we aren't thinking about these as individual clients, but as a community of people who have the capacity to act together. So I remember the first time that I saw this New York Times op-ed, I was working as a public defender at the time, that was written by Michelle Alexander, but was presenting this idea from a woman named Susan Burton. And I'm just gonna read 3 sentences from this op-ed because it was a series of questions that Susan Burton posed to Michelle Alexander. She said, "What would happen if we organized thousands, even hundreds of thousands of people charged with crimes to refuse to play the game, to refuse to plea out? What if they all insisted on their 6th Amendment right to trial? Couldn't we bring the whole system to a halt just like that?" This was the first time that I'd seen this idea of sort of defending collective power written out in public like that. I've since learned that it's not the first time it's been written out. I've found, at least back in the 1930s, a judge here in Massachusetts writing about this idea. In the 1970s, a professor at the University of Chicago Law School, Albert Altschuler, wrote an essay that included this idea. But the New York Times piece was different and felt special to me for a few reasons. One is just the salience of it. I mean, Michelle Alexander is a name that I suspect most people on this call, on this Zoom know. She's one of the most famous critics of mass incarceration. And here she was putting this idea front and center in one of the biggest forums in the world, the New York Times op-ed page. But beyond that, the framing was different here because it wasn't being presented as something to be afraid of or to guard against. It was being presented as something to consider as a potential means of actually combating the problems of mass incarceration. And I think most important of all, the perspective here was different because the idea wasn't coming from a judge and it wasn't coming from a law professor. It was coming from Susan Burton, who is someone who had directly experienced the harms of the penal system and who dedicated her life after coming home to organizing on behalf of people who the system harms. So I read that essay and just found it so inspiring and emboldening. And I wasn't yet a law professor. I was still a public defender when it was published. But when I became a law professor, I sort of knew from the beginning that I wanted to try to spend a chunk of my professional energy really taking this idea seriously, not as a metaphor or a symbol or a kind of dreamscape idea, but as something that might actually be real, as an authentic tactic that could be taken seriously and engaged with for its potentially dramatic decarceral potential. So that kind of led to two things that I'm hoping we'll spend time talking about today. One is this essay that I wrote earlier this year, No Justice, No Pleas, that sort of tries to do a deep dive into Susan Burton's idea and tries to do what I sort of just described, to take it seriously as a concrete proposal and map out what it might look like to put plea strikes into effect. The other is this the institute that you mentioned, the Institute to End Mass Incarceration, which I co-run with Premal Daria. A central mission of which is to try to help decarceral community organizers and decarceral lawyers, including public defenders, better understand how their two sort of complementary schools of practice can benefit from working together toward a world in which the harms caused by the American penal system don't exist anymore. So what I think I'll try to do, because I want to leave lots of time for just conversation, is just give a sort of quick sketch of the plea strike idea, so that it's sort of on the table. I saw something pop up in the chat, Katie. I don't know if it was a link to the
It's just links to the articles. Yep, yeah, exactly.
So if there's a link so there's both the New York Times op-ed that Michelle and Susan put out in the world, and then hopefully a link to the paper itself. And I won't sort of distill the whole thing. And if anyone wants to read more, it's there. I don't know how many lawyers are on the Zoom versus not, but it's a piece that I tried very hard to write in a way that folks from all sorts of different walks in life could read and find engaging and accessible. So I'll try to give a quick sketch of it here, and then we can flesh the rest out in conversation. I think there's really just sort of three main things I want to lay out. First is the basic premise of the idea of what a plea strike is and where it's how it sort of fits in to efforts to combat mass incarceration. The second is to just talk a bit about how the legal system itself actually and legal doctrines actually could amp up the potential or the serious threat that plea strikes pose to the penal system itself. And then I want to talk about one of the biggest obstacles to plea strikes, which is the potential backlash and concentrated harm that prosecutors might try to wield against sort of leaders of a strike. So I'll just start by kind of getting the basic idea out there on the table, because the premise of a plea strike rests on really just a few simple ideas. The first is the idea that resource constraints are the major decarceral force in America, more than law, more than sort of judicial doctrine, that one of the most powerful ways to fight mass incarceration is to make it harder for the system to turn free people into incarcerated people. It takes time and energy. It takes prosecutors, it takes judges, it takes court personnel to do that, to turn a free person into an incarcerated person. There's a process that the system has to go through, a kind of, a machinery of unfreedom that has to have its gears turned to turn free people into incarcerated people. And that system is not costless to operate, just like any other institution or bureaucratic machine. And if you make it more costly to operate, it will slow down. If you make it dramatically more costly to operate, it will slow down a lot and maybe stop. The second kind of foundational idea here is that machinery today is a machinery of plea bargaining. The Supreme Court has famously said our criminal justice system is a system of pleas. If you sit in any courtroom in this country, you will see this up close. When I was a practicing public defender, the court had what it called the morning calendar and then the regular calendar. And the morning calendar was just the judges going through the dozens of cases on their docket for a few short minutes of a hearing each, for the first maybe hour or so of court for the day. Sometimes they were just checking in on the status. But if you sat there, you would just see case after case get called up for a plea colloquy. And the same kind of ritual intonations over and over again with the judge sort of presiding over this. And in the span of a few minutes, you'd see a free person become an unfree person. And you would see it happen over and over again. Over the span of an hour, you could see dozens and dozens of convictions essentially generated right in front of your eyes through this machinery of plea bargaining. And every single one of those would take dramatically more energy from the system if instead it had gone to a trial. A trial in the simplest case would take half a day, many times would take multiple days, even for a simple case. You have to pull a jury together. You have to instruct the jury. Sometimes they could go on for days and days or weeks. So like the orders of magnitude difference in costs between the handful of minutes it took to generate a conviction through the machinery of plea bargaining versus what it would take to produce that same outcome, a conviction, through the process laid out in the Constitution, which is a trial by a jury of your peers. The last kind of key foundational insight is that even with that machinery of plea bargaining, even with all of that sort of saved resources, if you will, from the system's perspective, the machine is at capacity. Every one of these courthouses is like full to the gills in terms of how much they can push through their system, which means that they're dependent on plea bargaining to operate. At the beginning of the essay, I quote this prosecutor, Dan Satterberg, who was the head prosecutor out in Seattle. And he says that like a fish defending water, prosecutors cling to plea bargaining as a survival instinct. We can't take 100% of these cases to trial. My office files about 7,000 felony cases a year. We do 400 to 500 trials and we are packed. Our people can't do more than that. We've got an equilibrium in major city court systems where about 3% trial rate is considered a healthy trial rate. And it's really about all we can do. The upshot here is that the system itself is massively overextended. It's operating at full capacity. And even if just a small group of the people who are currently pleading guilty went to trial, imagine like 5% of them. If 5% of them decided to say, you know what, no, we want trials, you'd be doubling the resource demand on the system. It couldn't handle anything close to that. The massive overextension highlights just how much decarceral potential there is in collective action. A small group of people banding together could tip the system from what it's currently doing with its addiction to plea bargaining into a system that needs to find some other way to operate or to stop operating at anywhere close to the scale that it's operating at now. Once I sort of thought about this from a lawyer's perspective, it became clear that there's actually legal doctrines that are hardwired into the Constitution, that are hardwired in opinions written by like some of the most famous judicial conservatives who have ever walked the planet, right? Like Antonin Scalia, Clarence Thomas, doctrines that make the threat of a strike even more credible and more potent. Perhaps the most obvious is the right to a trial is itself hardwired into the Constitution. It's written in the Sixth Amendment, which means you can't just take away the not guilty plea if people start using it more. On top of that, defendants have all of these other rights that add to the cost to the system if they actually were to try to insist on trials. Before trial, they can insist that they can receive all sorts of evidence from the prosecution, either through discovery or through the Brady Doctrine, which triggers a kind of labor-intensive file review process on the prosecutor's part. They have to really look through their files to figure out what's in there and what they need to give over. There can be litigation over that if the prosecutors don't hand over the appropriate things. Once the trial starts, the defendants have a right to force the prosecutor to summon every single witness needed to prove every element of every charge. That includes eyewitnesses who the prosecutors have to track down, prepare to testify, and it includes some more mundane witnesses, lab technicians, police custodians, chain of custody folks who have to themselves then make their way to court, wait around all day, wait for their time to be on the witness stand. and then potentially get cross-examined by the defendant's own lawyer, which the state has to pay for. 80% of criminal defendants are indigent, which means that the costs that typically show up in private, litigation that are a suppressant on both sides, sort of trying to gum up the works and spend more time investing in litigation. Here, the state pays for both sides, which is a sort of important asymmetry in thinking about how these resource constraints work out. Finally, and maybe most importantly, the Constitution limits the prosecution's ability to work its way out of this resource jam. In part, that's because there's certain sort of doctrines around things like venue and speedy trial that make it hard to sort of spread people out over space and time. You have to prosecute people where the alleged incident happened, which means a courthouse bottleneck will be a bottleneck created in part by law. And there's a clock on how fast you have to be able to push everyone through from speedy trial doctrines that makes the pressure attendant with a police strike real pressure. And then most of all, you can't get the conviction without a jury agreeing to convict the person, which means that the local community itself, which could be organized alongside the people engaging in the strike, organized to support the people engaging in the strike, those community members have an opportunity not only to monitor what the prosecution is doing, but to potentially negate its most effective strike-breaking device, which is the threat of prison. But that strike-breaking device is like the last piece that I want to talk about, because it is serious and a real obstacle and potential objection to even talking about this kind of idea. Precisely because the system is at so much risk to this type of defending collective action, you can expect that system actors would sort of urgently need to break a strike if it ever tried to get underway, or to sort of stop its momentum in its tracks by targeting the leading edge of the strike, which creates a real dilemma. The entire community of people facing prosecution would be better off if they banded together, but some of them would almost surely be at greater risk and face more serious consequences if they go to trial. They're selected by the prosecution as one of the handful of cases to devote the resources to send to trial, and if they're convicted, because they won't then have the quote unquote benefit of a lower sentence that they would have gotten through a plea bargain. I think there's two sort of last key points I want to make about this piece, which I'm sure we'll talk about more. One is that recognizing the existence of this risk and this danger, I think focuses our attention on how any effort for this to be successful needs to really think through ways to mitigate that risk. Some of that could include choosing where to start a strike, how to try to protect people who are at its leading edge, how to sort of begin the strike or order the sequencing of things in a way that puts the most protected people in the most protected positions and protects vulnerable people. Some of that protection can be through legal defense, and some of it could be through community support, including real commitments to take care of people who are at the leading edge of the strike, take care of them, take care of their families, including through things like mutual aid, material aid, finding ways to make sure that they are not forgotten and that they are supported through the challenge of being at that leading edge. But the second, I think, more fundamental point is that I think we need to recognize that risk is a component of agency and of collective action more generally. Strikes have real risks. The Montgomery Improvement Association, when it engaged in a bus boycott, was taking on real risks. There were risks of harm. Labor unions, when they go on strike, are taking on real risks of harm. The United Farm Workers in their grape boycott took on real risks. Strikes also have rewards. I think the key is to recognize that it's not our role as people sort of talking about this from the outside to try to preempt or make decisions on behalf of the people who might bear those risks and reap those rewards. I guess another way to put that is like, I'm not actually in this paper or otherwise advocating police strikes. I think what I'm advocating is paying greater attention to their genuine decarceral potential, to take them seriously as like a real thing that could happen, as opposed to a kind of metaphor or quick idea. And I think I'm advocating trying to figure out ways to help empower communities that are harmed by mass incarceration, to minimize the risks, and if they want to reap the rewards of this type of collective action. And then to support them as they strategize through those trade-offs and as they consider acting on this type of collective action. Basically, I'm advocating for respecting their own agency to decide whether the risks and the rewards make sense. I think the last thing I want to say is that like the we in that sentence, the we who should sort of think through how to support those communities, can itself comprise a varied set of actors who have, I think, different roles to play in this type of scenario. I'm sure we'll talk about this a bunch more, but like two of those actors that I'm particularly focused on are organizers and lawyers. And I think that they have crucially different roles to play in this type of effort. And I think it's really important not to try to turn the lawyers into organizers or to urge lawyers to try to press their clients into engaging in strikes. In fact, I think that would be deeply problematic. At the same time, if your clients are organized, if your clients come to you and say, look, there's something going on here in our community, I'm part of something, I'm part of a movement, I'm part of an effort, I think it's also deeply problematic for a lawyer to try to talk a client out of that. I think a lawyer's job is to help their client fulfill their own agency, and that can include their collective agency. All right, why don't I stop there and see what sort of questions you might have, Katie.
Phenomenal. Thank you for that overview. I think that was really helpful to kind of grip the conceptual framework. And now we're going to try to dive in together to some of those complexities that you just kind of teed up for us, right? About how would this actually get operationalized and what kinds of cases might be the potential good testing ground and those kinds of nuances. And a reminder to the audience that at any point, if you have a question, please feel free to drop it in the chat or raise your hand. So I'll start with a couple of questions. One is more focused on some of the research in the piece. You just alluded to one example of, a specific historical context in which we saw defendant collective action, right? People who had been arrested en masse, deciding together how to engage the criminal punishment system as a collective, right? Many of the examples of that kind of collective action among accused people in the research come from people arrested in connection with existing social movements, right? Who already have social bonds and who also already have a common political commitment to a particular ideological goal. In the case of the Montgomery bus boycott, right? A specific context. And given that landscape, what are some of the challenges in adapting these methods to run-of-the-mill criminal prosecutions where people may be more disconnected from one another and it may be harder to envision and enact that kind of unity of interest?
Yeah, I think it's such a great question. I think there's sort of two key things that it raises, right? One is the kind of optimistic piece, which is like, there is some proof of concept here. Like, in other words, police strikes are not entirely hypothetical. They've happened. They've happened and they've been successful. You know, I saw looking through the participants, there's some folks on the Zoom who have some real direct experience with this, either as defendants who engaged in collective action or lawyers who represented them. The most common context that I'm aware of are what you described, essentially mass protests that then lead to mass arrests and mass prosecutions. An example that I talk about in the piece, and that is one of the most recent and most prominent, is the J20 prosecution in DC, right? 200 plus people prosecuted, all charged with variations of basically felony rioting following Donald Trump's inauguration, who organized into defendant steering committees, really collaborated together on a collective defense, including many of them signing a pledge not to plead guilty. And no one who signed that pledge got convicted. Almost all of them had their cases dismissed because it jammed up the DC court system so intensely. And the ones who went to trial were not convicted. In fact, one of the biggest consequences was that there was a professional responsibility investigation into one of the prosecutors on the case for not disclosing Brady evidence. The only person sanctioned essentially through all of that was the prosecutor, not the defendants who banded together. All of this is just to say, this is not like hypothetical. At the same time, your question is so important because it highlights the massive differences between those examples and the setting I'm talking about. Differences, some of them socioeconomic and demographic. The people who travel around the country to protest are not the same people. There's obviously overlap. But these are different communities and have different relationships to the penal system, different privileges. But also, as you say, the folks who come together in a protest situation are in some sense almost pre-organized. They showed up there all at the same time for a reason. There's a shared ideology. There's a shared infrastructure potentially of organizing. On the flip side, there are things that people, the communities I'm talking about, also share. Right, that's where I started. Right, they have what Marshall would call a sort of shared stories that tie them together, that grow out of their shared experiences with their local penal system. In other words, unlike people who come from all over the country to protest in a given city, these are people who already live together and are living the shared reality of what it's like to be, in many instances, under the heel of the local version of mass incarceration in their community. And that can be a powerfully unifying experience. I love it. Someone just wrote in the chat, story of us. That's exactly it, right? They have a shared story of us. That's what organizers call this. They have a shared narrative and a shared lived experience that, if turned into a motivating story, that's not just a story of the injustice they are experiencing together, but rather how there is a way in which together they can overcome that shared injustice, that can be powerfully motivating. I guess that's just a long way of saying the ingredients for successful organizing, I think, are here too. And that the similarities, or at least the potentiality of collective action in this setting, I think there's a lot of things in its favor, even as we recognize that it's, it would be too quick and almost irresponsible to say, oh, well, it works for the protesters, so let's just, try it over here. The differences are dramatic, but there's also real resources, including interpersonal bonds and networks and shared experiences that organizers, I think, would have a lot to work with to try to generate that type of energy and collective action in the setting I'm talking about.
Great, thank you for that. We have a lot of questions and engagement from the audience, which is phenomenal. I'm going to go in the order in which I saw them, which is first to Felix, who has a hand up, and then to those of you who have offered your comments in the chat. So go ahead, Felix.
Hello, sorry my camera is not working, but thank you for a great talk. I think it's a really compelling idea. I wanted to just ask about really, I think you highlight how sort of unexpected or unnatural the current equilibrium is, where almost nothing goes to trial. And that's something that I think is very surprising to a lot of people. I think of that as an equilibrium that sort of arose over time through a series of processes. And I'm imagining a case where we see a substantial change to that equilibrium as one that sees a response, right, in terms of either system adjustment of prosecution and other parts of the system, or counter organizing on the part of people in the community who don't like this change. And so I'm trying to think about how we can anticipate how that might occur and plan for it to make this likely be successful. I'm thinking about analogs to something like when we see conversations around reducing policing footprints, we see volunteer police programs, neighborhood watch, direct donations, and organizing for increasing police budgets. And so I'm imagining, should we think about volunteer jurors who are trying to be like, you need a trial, I'm here to do a trial anytime you want. Trials being faster and more performative, thinking about longer times to adjudication, shifting costs for these kinds of things. If you need an expert, for example, to defendants, all the kinds of things we've seen in other contexts. And I'm just, the last thing I'll say is natural fluctuations in just propensity to go to trial. If we're thinking about a base rate of 2%, 5%, if one year it's 7% or 10%, that's a huge change, as you pointed out. And so maybe those kinds of sort of natural fluctuations could be instructive, just because it takes such a small change to fully gum up the system. Maybe what has happened where we've seen trends in trials change over time. So sorry for the compound question, and thank you for your response.
Thank you for the question, Felix. It's nice to hear your voice. I think it's a really central question to the whole thing, because none of this is static. Right? You have to assume, I mean, sort of as I said, precisely because the threat of this type of tactic is so large, that the counter tactics would be immediate and swift, because the system would have to try, fight with all its might, basically, to defend against this type of intervention. And I think the pushbacks would be along all the dimensions you talk about: political, financial, legal, right? Financial, look, a major potential downside to an idea like this that's basically built on resource constraint as the decarceral force is that folks decide, well, we need more resources, right? If you're going to double the trial rate, we're going to triple the budget. If you're going to quintuple the trial rate, we're going to, dodecagon up the, whatever times 12 is, we'll up you each time, right? And end up with even more investment than there was before. Like that's a pathway that we have to recognize and then be prepared to guard against. The other backlashes you talk about are right, like the political. We've seen the backlash to a related resource constraint-driven decarceral move, which is defunding and reallocating dollars from the penal system to other types of investments in social welfare structures that are improve people's lives and depress crime. Like that's the basic move being advocated for in defunding, right? Invest in the things that both help communities avoid the harm of the penal system and avoid crime in those same communities better than each dollar spent on policing. That move has produced a backlash, right? To the point where, many leaders of the Democratic Party are, reinitiating calls for hundreds of thousands of more police officers, a sort of cycle that we've seen before. And then there could be legal backlash, right? I mean, gosh, Justice Scalia might like the Sixth Amendment a whole lot less, were he, I guess, still alive, and B, recognizing this strike, like if it happened, that might change the way that people like him think about these legal doctrines. Legal doctrines can change. If there's anything a lawyer knows, it's that there really isn't a legal doctrine out there that cannot be revised, rewritten, overruled, as we've seen starkly in the past few years. All of which is to say, a police strike is a tactic. It is a tool that one might use as part of a strategy, a broader strategy. And it has to be situated within a strategy. You have to think through what these moves and countermoves look like, and then make the decision about whether the tactic is even a valid or valuable one based on some of that pushback. But it also means that you have to be prepared for the pushback and already be organizing around that, including being prepared to figure out, okay, how do you push back against the inevitable narrative that says, well, why don't we just invest more in the system, right? You have to be equipped to do the organizing work that is happening now already, that's trying to push for deeper investment in the social structures and institutions that are trying to help improve public health and people's lives and mental health, as opposed to using the carceral system as a response. You have to have that happening at the same time as this, because a police strike puts pressure on that idea, right? You have to be prepared to sort of shore up that backlash. On the legal backlash piece, like, you need lawyers ready to help and try to anticipate where that pushback happens and what legal defense of the things that make the strike possible look like. You need tactical lawyering that is in conjunction with the overarching strategy. I guess that's really just a simple, a long way of saying, Felix, like, yes, this is dynamic, and you can't expect to throw a punch and not get punches back. And you have to be thinking of what that iterative thing looks like, and be prepared, and have laid the foundation to be prepared for those countermoves.
Thank you so much for that. Okay, so we've gotten a number of questions and comments in the chat, and some of them are raising similar themes. So I'm going to try to weave a couple of them together. I know it is generally our approach that we try to let everyone ask their own questions, but given that we've got that duplication, I want to try to get to as many of the topics as possible. So one thing that is a theme coming out of these questions is the true cost is borne by the defendant, right? For many people, that is going to mean sitting in pretrial detention, which is a way that prosecutors extort pleas functionally, right? Which is a big theme in your piece. So some of the questions around that are, I want to shout out Spike, who raised that question up. Is there an opportunity to think about outside of a strike scenario, how changes in the pretrial system that lead to less detention might also work kind of in tandem with this, to see how the system could deal with fewer pleas? And then another kind of theme and variation on that, is there a way to assess the cost to the court system of using incarceration to extort pleas? Is there, like, instead of thinking about exclusively the harms to the defendant of bearing that cost, which I think really are the greatest cost, what would it look like to spell out kind of the political economy costs on the court system?
So I'm going to sort of dive into the pretrial detention piece first, and then I might ask first some help on the second one, making sure that I've got it. But I think pretrial detention is like as you say, like a major piece of this, right? It's the single biggest driver of convictions. There's really great work by one of my colleagues here and your colleagues there, Crystal Yang and Will Doby have done this great work on showing how that one decision, whether someone gets detained pretrial, I mean, Sandra's work on this is like really just terrific, right? Like, is the thing that sets people off. It's like, it's the major fork in the road, right? Pretrial detention, on whether you're going to be convicted, what the like long-term consequences are, because of that intense pressure to plead guilty when you're incarcerated. So a few thoughts on that piece. One, and this is just getting into some of the like almost imagined strategy work that would have to happen up front as organizers try and figure out like, how would we do this, right? This is almost like an imagined version of like what maybe like some of the whiteboard kind of looks like, trying to think through this. One thing to realize is the system is incredibly fragmented, both siloed across sort of jurisdictions and stratified vertically, which means that like some of these legal things that I sort of gesture at change a lot from place to place. In other words, protections against pretrial incarceration vary a lot by state, in part because of organizing, right? So I'm thinking of like all of the organizing that went into the Pretrial Fairness Act in Illinois, right? Like massive organizing to build up those types of protections. And then those legal protections in turn impact how easy it is for the system to crack down on strikers by locking them up. So part of that is like thinking about where you are in a specific sense, right? Like, I guess another way to put that is like strikes might be more or less successful depending on a whole part of the ecosystem that they're in. Related to that, though, is the system stratified vertically, right? Most people are not detained pretrial. Most people are going through the system and potentially like for charges that are not even eligible for pretrial detention, or many of them are. At the same time, jails also have resource like constraints. Like it's hard to immediately build a new jail. Now, that's not to say that the system wouldn't respond in all sorts of other ways, like potentially shipping people, making, detention, impromptu detention centers, or shipping people to different locations. Like these are all the things you have to, again, in the kind of dynamic point I made with Felix, like anticipate and figure out how to guard against. But precisely because the system is so stratified, you could potentially imagine folks, the organizers in the moment of the campaign, trying to figure out where to start and who is most protected, including potentially trying to start again among people who are not at serious risk of pretrial detention or who are already released, and sort of, to use Michelle Alexander's phrase, like crashing the misdemeanor component. There's Professor Jenny Roberts wrote an article teeing off of Michelle Alexander's piece that was focused solely on the misdemeanor component. Gosh, let's crash the misdemeanor system. And was, I think, keying off the idea that like misdemeanors are less vulnerable, people facing misdemeanors are less vulnerable to some of the counter moves that you would expect from the prosecution, and as a result might be more emboldened or more protected. These are the types of sort of tactical, judgments that one has to make thinking through, which again, I think just highlights the power of linking up organizers and lawyers, because it's lawyers who kind of know these minute gears that end up being really important tactically and strategically, and the information sort of sharing that can happen at that tactical stage from that shared knowledge, I think can be really powerful. I don't think I quite got the second question, but I don't know. I'm going to leave it to you, Katie, to figure out where we go.
No, I think that's great. Yeah, and I was just going to drop in the chat, to one of the points you just made about, anticipating the externalities and the responses, right? Of thinking about that, you teed up the notion that in addition to dealing with the organizing infrastructure just to get agreement around the police strike, right? An organizing infrastructure would also need to exist to support people materially through the process of striking against the plea, right? And that means if people are stuck in jail, what does it look like to support them and their families, and to support their most robust possible bail motions, right? Like what are the ways that could happen in a legal organizing context and in a just strict organizing context, right? In terms of financial support, if somebody who was, the major financial backing of the family is not available anymore because they're stuck in jail, right? What does that look like? What kind of organizing would be required? But I think also one of the other pieces of what you just said that I wanted to drop this information in the chat about is there was evidence that when there were massive impact litigation efforts to deal with overcrowding in, decades ago, 1970s to 1990s, the response wasn't incarceration, as people might have hoped, due to those conditions issues. The response was a jail and prison building boom, right? And so and that's empirically documented. And so if you're right that the system will contort and find ways to reinvent itself, and to reify the existing pieces that are maybe being contested, even in a kind of legal framework like this, right? So I think that that's in some ways, depressing example, given the history of that effort, and also tees up, a question for me about some of the existing organizing infrastructure. And I dropped a link to Pilar and Raj's piece on the LPE blog from, I guess, 2 summers ago about kind of existing forms of contestation and criminal punishment. But some of the, that work is really trying to disrupt the idea of reformist reform, right? Trying to not take the system at its own terms. And there's a part of me that wonders if this idea, which is really, as you say, rooted in conceptions that are constitutionally protected, right? The right to a fair trial is written into the Constitution, and in that way is could be championed as a reform effort that fits into that notion of a reformist reform, right? It would allow the system to morph into a way that reinforces the idea that it is providing justice, and that there are fair outcomes potentially, right? That there are risks around that conceptually too here.
Yeah, that's great. I think it's a few different questions. I'm going to see if I'm trying to think for a second of how to come in at it. So I think, to your point about backlash, I think, and prison booms, right? I mean, it's a version of Felix's sort of question from before. And the only additional thing that I'd say is sort of tying in the answer I was giving to Spike on sort of stratification and fragmentation. You also kind of get to pick you could imagine that strikers get to pick, or organizers get to pick their opponents, and they get to pick their enemies, if you will. Which means, like, there's a real question of, like, is this an idea that is better to pursue in jurisdictions that are already trying to be decarceral? Or is it an idea that's better to pursue in, the worst of the worst, right? And I think that influences the backlash point, right? So when you were talking about, prison booms in response to decarceral orders, I then also thought of, like, the multi-decade litigation in California that ended with, a massive decarceration order, right? And that produced a real drop in the prison population, in part through sort of changing the revolving door around probation revocations and things like that. And I think it's meaningful that, we have to situate all these things contextually in history and in place, right? I guess what I'm saying is some places are more likely to have a really bad backlash, and some places are perhaps create at least the space to respond to a system shock by questioning what the system was doing and using system shock as an opportunity for real, like, introspection about where we're supposed to be taking this, especially if there's pressure coming from the community to have that kind of, like, just really dramatic change in direction. And the community you're in, and you know what sort of backlash might happen, and that's part of I think the calculus and the decision. The only I'll say quickly, I love Raj and Pilar's piece, and I think quote from it a bit in the essay. One of the major things I take away from them is this point about agency, and that, the organizer's job is to try to let the community lead these sorts of efforts, as opposed to dictate to them or impose them, or, like, least of all, be like, oh, I have this interesting idea and it sounds like this really cool theory, so let's go try it, right? Like, I think there's a danger in sort of taking this kind of as a law review article and just sort of getting enamored with it or infatuated with it and pressing it, as opposed to trying to treat it as a potential tool that a community might find valuable if they wanted to use it. And I think that I kind of think of the legal rights component of it the same way, to your sort of reformist reform bit, right? Like, my suggestion of the role of law in all of this is that it's tactical, it's instrumental, it's a tool that might be used, as opposed to sort of something that we want to kind of reify as, like, a golden answer, right? So in other words, I'm sort of almost suggesting the opposite. I'm not trying to say, like, oh, don't worry, like, we've got this magical Sixth Amendment that's gonna, take care of everything. Like, thank goodness. It's almost, let's recognize that for the moment, we have Sixth Amendment doctrine that could be instrumentally valuable to organizers who are trying to figure out what their resources are. And that some of their resources are actually resources that come from the legal system as it currently exists.
Okay, we've got definitely more questions in the chat, which I'm going to come back to, but first I want to go to our 2 hands up. So Jonathan, you are up next, and then we'll take Herbert.
Well, say a couple things. I think a foundation of this might be people who are factually innocent, if you can reach them. The conventional belief is that 4% of people who are convicted are factually innocent. Having worked at Hampton Correctional Center in Massachusetts for 30 years, I think that's a very conservative number. I think there are quite a lot more than that, especially if you can also consider people who are guilty of some things, but the prosecution wants them to plead guilty to something else, and which they are factually innocent of. And so if you include those, you got quite a group of people there. I also want to say on the negative side, when I went to work there in 1988, the jail was built for 250. We had 880 people there. They found a way to put them in. So that's part of the danger. And right now at Hampton Correctional, I think there's somewhere like 800, 750 people. They can house 250 without breaking any laws. So we've got to be aware of that. Thank you.
Thank you for the questions. You know, on the second point about jail conditions and overcrowding and the idea that the system will just find ways to just keep, putting more people in. I want to really underscore the point that I shared some with Katie in the initial bit. Like, this is not a risk-free idea. This is contested, sharp-elbowed politics in a certain way, and there's real risks with it. And I don't want to seem at all Pollyannish about that or dismissive of it. I think it's real. I think all I'm trying to suggest is that I think that also that there are moments in our shared history of people coming together to protect their rights and improve their lives that involve risk. Okay. We can think of stories that we tell ourselves now that are real stories and that are ones we hold up as moments of inspiration. People linking arms and crossing the Edmund Pettus Bridge. There's danger in collective action. And I think that we can't be dismissive of that, which is why I really say, I don't think that I'm here advocating this. I think at the same time, though, we need to recognize that it's the people who are facing those risks and who are also facing the other risk of the harms of being put through the system, having a conviction, mass incarceration, and the harms that does to their communities. It's kind of risks all around. And we need to, I think the goal is to help people figure out how to activate and act on their own agency in that. To your first point, I'm trying to remember. I'm sorry, Katie. I think I missed the first part of the question, and I remember that I had a thought to say about it. But
no, that's okay. Jonathan, did you want to reprise?
Yeah, it was just that I think innocent people, factually innocent.
Thank
people.
you. Right. So I think that this, in my head, fits into some of the real tactical points I was raising about, like, there is asymmetry of information between the people in the strike and their lawyers and their defendants and the prosecution. And the prosecution's goal, if you try to think through this just in a kind of almost game theoretic sort of way, is they obviously want to put folks at the front who they are confident they're going to get quick convictions of and who they will get long sentences against to try to just break the spirit of the union. But the union has information about who might be the strongest cases, and they might not be the folks who the prosecutors think. And I think the J20 example is really interesting in this respect, right? Like, I mean, part of the reason it all unraveled is the prosecutors put forward what they thought were some of their stronger cases. And then there was coordinated maneuvering by the defense lawyers and the defendants that ended up being that the cases that went forward first to trial were not as strong as the prosecutors thought. And the juries didn't convict. And there was massive resources that the prosecution put in to try to break the strike, and they lost. And a loss there can be a really signal thing for this type of effort, right? And all I'm trying to say is the folks who have the weakest, the folks whose the cases against them are the weakest, which may be some folks who you're describing as factually innocent, Jonathan, may just be people who have weaker cases for various reasons, are people who are potentially, compared to others in the union, better positioned to kind of go up front. And all I'm trying to suggest here is that the union and their lawyers may know that in a way that the prosecutors don't, which again is a kind of potential strategic resource that's available to folks engaging in this sort of, or considering this sort of action.
Go ahead, Herbert.
Hello, can you hear me?
Yes.
Oh, great. Professor, I want to preface my comment and my question by saying I admire your work. I'm a strong admirer of yours, and keep up the good work. I applaud you for what you're doing. I mean that sincerely. I come from a background of primarily doing criminal defense for almost 30 years.
Mm-hmm.
And just a couple of years ago, we got a newly elected progressive district attorney in Gwinnett County, Georgia, north of Atlanta. And I've joined her administration. And so I'm a prosecutor. And you've been on the public defender side. And so you know what it is like to defend people who've been charged with crimes, serious crimes. And at least my experience, I know what the movies show, but in my experience, most of my clients out of 30 years were guilty. The government could not always prove their guilt, and I got them off, and that's our system of justice. But my fear is, I'm reminded of that notion from the Vietnam War about destroying the village to save it. My concern is that your idea may be very good and very effective, but the effect of it is that you can bring down the whole system, and that there are a lot of violent criminals who will not get their day in court because the system has been so clogged up, and there are a lot of innocent victims, real people who won't get justice if this is carried out. And so I guess my concern is, and my fear is it worth it? I just want to get your thoughts about the other side, the victim side, and if this is the best way or a good tactic, because of course, as a lawyer, we know we are also officers of the court, and we have a responsibility to the bar. Again, I admire what you're doing, and I just wanted to get your thoughts on that. That's one of my concerns. I want to do the right thing. I'm less concerned about the misdemeanor cases, I'll be honest with you. I'm more concerned about there's a violent crime happening in this country every few seconds. That's for real. And you're right, the courts, we can't try all these cases. We just can't. And yet, I fear that your recommendation of this idea could have some negative effects that outweigh the benefits. I just want to get your opinion. So thank you so much.
No, thank you. I mean, I think it is an important question, especially once we remember that the double injustice of how we approach crime in our country is that the nature of structural, longstanding, and systemic injustice and racism around these issues is that it's the same communities, right? It is the same communities that are bearing the brunt of mass incarceration that are also bearing the predictable costs of decades and centuries of underinvestment in exactly the types of social institutions I was talking about that have the predictable consequence then of concentrating some of the harm you're talking about in those same communities. I'm thinking, and a well-documented kind of phenomenon. I'm thinking here of James Foreman's work, talking about how you could then imagine how it is sometimes exactly the same sort of communities sometimes pushing for. James's point was they were pushing for two things. They were pushing for social investment in exactly those structures to deal with the root of the problem, and they wanted to be protected. And all that they got was quote unquote protection in the form of more penal system and not the investment in the underlying structures that would be getting at the root of the problem. All of us should just say, I think the point is real, right? Like that there is a potential harm that you're talking about that we shouldn't ignore. I think what I'm trying to ask or what I'm trying to do is not provide an answer to that question, but rather provide a different idea for how we answer that question and who gets to answer that question. Really what I'm advocating is a recentering of the locus of gravity of political power for how those hard questions get resolved. Where do we invest? What do we invest in? How do we try to deal with some of these root causes of crime? What's the most sensible way to do that? And rather than rely on a system that itself has some of those same structural injustices that then push the voices to the side that ought to be the voices driving that conversation, figuring out alternative ways to put real power and agency in the voices that have the most at stake so that they have more capacity to determine basically that big picture public policy question that you're asking, which is where do we figure out what we should be investing in and how? What do we think are root causes of crime and how do we respond to them? What tools do we use? Do we use the penal system alone? Do we use the penal system primarily? Do we use alternatives to the penal system? How do we put that together? Really what I'm trying to do is find a way to push to the table with real power and agency to be participants in that discussion, people who otherwise don't have access to the levers of power that are currently driving how those decisions get made. You raised a separate point about lawyers' ethics, Herbert, that I'm just going to sort of leave aside in case someone raises it. But I think that there's a lot of interesting things about what a lawyer's ethics are in this situation. And I think that they're downstream of organizing. I think that if your clients are organized, your ethical obligation is clear. Support them in doing what they're trying to do. And I think if they're coming to you solo, I think your ethical obligation is also pretty clear. Don't try to push them into doing something that you think is a exciting, radical idea. Let your client be the driver of their case, including if their client is collectivized and organized, support them.
I think that is something that's come up in the chat a little bit, and I think it might be helpful just to speak to that in a slightly different context too. One of the things that lawyers are taught in ethics classes in law school is that if you are engaged in client representation, you have one ethical duty and it is only to your client. And also we know one of the other things somebody brought up in the chat is that it is fundamentally a defendant's individual decision of whether to accept a plea or not, right? And so those are both important ethical guideposts, I think, in thinking about this, as you've just said, but maybe not determinative of how to engage in this work. And beyond the specific context of a plea strike, I think it would be really helpful if you have thoughts or have been spending any attention at the Institute to thinking about how can lawyers be more involved with organizers in this space in general, right? I think so many lawyers are afraid because of those ethical boundaries to feel like they're ceding control of their clients' decision-making to other people in the critical components of a case, right? And that if their client is engaged in a practice of organizing, whether it's participatory defense or whether it's court watching or some other kind of mutual aid and constant contestation framework, right? That it can be hard to say, okay, I'm going to talk to these other people about your case while you're sitting in jail, right? Yeah. How would you think about how lawyers can be more engaged in organizing work and help their clients do that?
I think these are great questions. I think there's a difference between, let's just call it a lawyer or a public defender's ethical responsibilities, and separate from that, the ethos that we, and I say we lovingly, in the public defender world have sort of built up around what we think it means to be a public defender, or some of us sometimes seem to think it means. And I think that I want to treat those two things separately. I think the ethical obligations are to zealously fight for what your client wants to happen. So when we say, like, gosh, it's drilled into public defenders, your client comes first and you do whatever they want, that slides into sometimes saying something like, all you care about is your one client. I think this is why organizers are key to this, because if your client is telling you, I care about my community, and I actually think that I'm in solidarity with other people here, and that's not just a slogan, that's something real. I've been to meetings in my community. Let's realize part of the consequence of mass incarceration hyper-targeting localized communities is we know who's going to get arrested. The same communities are having this happen all the time. You can organize a community before people get arrested. So it's possible for the clients to show up already part of something bigger. If that's how you meet your client, I actually don't think the ethical dilemma for the lawyer is so complicated. Your client's telling you what they want to happen. Your job is to give them advice and guidance and not to try to knock them off of what they want to do. As you say, it's their decision whether or not to plead guilty or not to plead guilty. And their reasons for not pleading guilty can include that they think that that is in the best interest of a broader group of people that they care about and are trying to stand in solidarity with. So in other words, the ethical thing, I think it is unethical for a lawyer to try to be the leader of all this. I think it would be bad if a public defender's office, if someone on here is like watching and is like a public defender's like, oh, I got to go back and tell all of my coworkers that we got to tell all of our clients not to plead guilty, because like that is, I think, problematic. There's tremendous power disparities between the public defenders and their clients, just by virtue of who has a legal degree, who doesn't, who has knowledge about how the system works, who doesn't. I think it would be bad if public defenders tried to be the organizers here, because they'd be stepping out of their role as lawyers. All I'm trying to say is that their role as lawyers can include being supportive of their collectivized clients if their clients are giving that direction. That's where I get to the idea of then ethos, because I think that we've built up a broader ethos of public defense that is in some versions in tension with this idea, right? We sometimes the lawyer leans into saying, look, all I care about is you. My job is to protect you, nobody else. And to almost be leaning into the atomized or individualized idea of who the client is. And almost, as you said, right? Like I read this at the end of the piece, like my instincts, how I was trained as a public defender, if my client said, hey, everybody at the jail is sort of co-strategizing, every alarm would have been going off, right? I would have been trying to tell them, look, that's all good for them. Let them strike. You just listen to me, okay? Like, my job is to protect you and get you through this. I don't want you at that leading edge. I don't want you sharing information with everybody that could all get, subpoena, all this stuff, all of these risk-averse things. And I'm trying to sort of suggest that we as lawyers might want to rethink that ethos. If our own fears or built-in risk aversion is becoming a suppressant on, or is at risk of being a suppressant on what a group of clients might ask for, if they actually are organized in the community before they come to the lawyers.
Yeah, that's great. That's very helpful, I think. And I would just encourage anyone who is, I know we do have a lot of public defenders on this call who are thinking about this, that there are, try to tap into existing organizing spaces that happen already, right? That I think that's one insight from your piece too, right? Is that lawyers cannot be leading the charge. And so organizers will be, to the extent that this idea could be actually materializing in a specific jurisdiction. And so what does that look like in terms of not only, you talk a lot about there would have to be an infrastructure among organizers with directly impacted community members, but I think there would also have to be an infrastructure between organizers and lawyers who would need relationships of trust and would need to be able to rely on one another. So how can you start laying the groundwork for that, right?
Yeah, and you'd asked a bit about some of the work at the Institute that that we're doing around this. I mean, this is one of the central missions of the Institute. It's why Premal and I sort of built it up, and one of our main goals for it is to try to create exactly some of that infrastructure for a sort of these parallel and kind of orbiting theory practices, just try to get strengthened and grow together, organizing and decarceral organizing and lawyering. So some of that includes trying to figure out ways to actually bring these two communities closer together, create spaces for interaction, sharing of these ideas, sort of side-by-side training. So I saw on the participant list some folks who came to this collective defense workshop that we hosted a few months ago, which is this terrific sort of 2-day gathering that was a sort of mix of organizers, including folks from the participatory defense hubs, lawyers who had done some of the protest defense work that I'd mentioned before, including lawyers from the National Lawyers Guild, who have experience with that, public defenders, and to kind of put all of these folks in a room, and then folks who have engaged in some of this lawyering outside the penal context, right? Like tenant organizing and the relationship between housing lawyers and tenant organizers when there've been rent strikes, right? Like they're trying to learn from and create space for these types of exchanges for folks to recognize, gosh, there's so much synergistic potential of putting those types of folks in a room and treating them as part of one big strategic cohort, right? Who each have perspectives that when you add them together, fill in the gaps in each other's knowledge. We all come in with our sort of expertise and our gaps. And one of the things we're really trying to do at the Institute is create spaces where we can both bring those voices together and then do some of it in practice, right? You know, we have a clinic at the Institute where this coming semester, our hope is to be actively engaged as lawyers in decarceral organizing campaigns, right? We've got, you know, terrific folks on our team who are like doing the hard work of building the relationships with those organizers in their communities. And, you know, it takes work to build that trust, to build those relationships, and then to figure out what is our value add as lawyers and how do we avoid the two twin dangers of lawyering in this space, either talking too much or talking too little. Right? Either showing up and thinking, okay, I'm the lawyer here, I've got the degree and I know how, like, don't worry, we're going to file an injunction. We're going to, like, you know, you don't want to, that's not the job. The job is to let the organizers drive and the community drive what the strategy is. At the same time, you don't want to show up and just sort of think like, okay, I want to make sure that I don't, you know, overstep. And so I'm just going to sit and wait to be kind of called on and not share the knowledge that I might have that could be strategically useful, right? And it takes real trust to be in a place where then you can have those types of conversations where you're neither overstepping nor understepping, but rather just one of the people on a team, right? I mean, for the organizers on the Zoom, there's got to be at least a few, if Story of Us is showing up in the chat, right? Like, that's what teams are. You know, organizing is built around teams and people who bring their different perspectives and resources to bear. Lawyers have tremendous resources, and we should be wary of hoarding them, or of thinking that they're only useful if we're the ones using them in the ways that are conventional ways that we've been taught to use them, which is filing a suppression motion or giving a great closing argument or something like that. We have ways that we can be contributors without overtaking everything.
We've got a question from a little while ago from Jeffrey Fagan that I think is kind of teed up by the point you just made of looking to people from other contexts, and thinking about how to build in, you know, people who are doing, you know, tenant organizing and rent strikes, or, you know, the debt collective that's doing student debt strikes, or, you know, any number of other kinds of places that are engaged in that kind of contestation. But I think that then also leads to thinking about the you know, alternative responses, right, of what have already happened in those kinds of social movements and how do they react. And so the question was, might one response from the state be to push the boundaries of permissible cruelty in detention conditions, right, a form of strike breaking like withholding health insurance and labor strikes? So I wonder, you know, you could answer that question certainly in our last couple of minutes, but I think teasing out from that question, right, how can, in playing this out into the next phase of the hypothetical, how can we learn from those same movements in thinking about what to anticipate, which goes back to Felix's question a little bit.
Yeah, and hi, Jeff. I think it's a great question. I think all the questions, I mean, thank you to everyone who has asked these questions because they're just so enriching and exciting. And yes, absolutely. I mean, I think that there's so much to learn from organizing and collective action in other settings, right? Some of the, I mean, that's why, in addition to the folks who I sort of, you know, mentioned at this collective defense workshop, you know, we wanted to talk to people involved in student debt organizing. We wanted those voices at the table. We wanted housing folks who have done it in the rent context at the table, because there's a common through line through this, right? I mean, I don't want to, again, overstate the similarities, but I don't want to undersell them either, right? Collective action is something that has time and again demonstrated real power in our shared history, right? In the United States and more broadly, right? Like there is a real power to it, and it is ways in which people who don't have access to conventional power are able to claim the power that they have just by being communities together, right? We see that in housing context. We see it in labor. We see it in immigration. We see it in basically any domain in which systems are working to oppress large groups of people. There's the capacity for those people to try to find ways to identify the resources that they have in common and to leverage them. That's really what organizing is. Of course, there will be backlash. That's the nature of what contested politics like this looks like. And in the context of the penal system, that backlash will be painful, because that's what the penal system is. I mean, I tell this to my students on the first day of one old criminal law. So what is the criminal law? What makes it different from other bodies of law? It's the one body of law where the state is explicitly trying to hurt its own people. It's inflicting pain. That's what punishment is. Punishment is pain. Now, there might be reasons why the state does that. And anyone who's taken criminal law knows there's a whole bunch of philosophical reasons that are put out to justify or try to explain why that punishment is legitimate. But at the end of the day, it is pain. And so if the system is going to push back against this type of thing, it's going to do it in ways that are trying to cause pain. And then incarceration is painful. And so I think Jeff's point is a version of Felix's. And I think the answer has to be the same one that I've given a couple of times, which is you respond by first trying to anticipate what that backlash will look like. Think through how you can get ahead of it and minimize it, how you can be most prepared as possible. And then also recognize that there's potentially pain in both directions. There's pain in not fighting the system. That's the pain of what mass incarceration currently is. There might be risks in fighting it. And I think the job of folks who are trying to be supportive of communities doing this work is to treat them as communities that really are the ones who should get to decide this. Help them figure out how to build that power, how to strategize together, and then how to use the power that they're building together.
Well, I know we are at time and also that we have more questions. I don't know if you have 5 more minutes, Andrew, to stay on if people want to stay on, but I don't want to impose that on you without pre-clearing it with you. You know, I know Kathy has had a hand up for a long time. So Kathy, if you want to ask your question. You'll have to unmute first. There you go.
Yes, thank you. Thank you very much. So I've been fighting for a law that specifically asks that we do race and ethnic data collection in the juvenile justice system. And the problem is when you do race and ethnicity data collection is you prove racism. You prove this, we already know it's racist, but you prove it's racist. So the court has been fighting against this. The Massachusetts court has been fighting against this law passing. And I guess when I'm sort of, tell me if I'm correct in understanding this. In over-policed communities, you need more plea bargaining because you have more people coming into the system. Is it dependent on, we're dependent on plea bargains which play out in racist and classist ways. Are we dependent on the system being racist? I mean, is the court dependent on the system being racist? Which is cheaper to be racist, if that makes sense.
I'm trying to think. Go ahead.
Well, so for example, like I worked with a lot of Black youth when I was working with incarcerated youth, with incarcerated youth. It felt to me like if they had been richer, they would have had more resources to not, to not sort of accept those things.
Yeah, so I think that your question sort of prompts 2 quick thoughts from me. So the first is, when we try to think of what we mean by the phrase mass incarceration, I think lots of people define it in lots of different ways, but we sort of have this whole section on the website for the Institute to End Mass Incarceration laying out what it means to us, why we use that phrase, and how we define it. And the 2 central features for us are in part the massive scale, but then also the massive racial injustice associated with it, right? So it's not just the number of people that we incarcerate, but who bears the brunt of that. And the historical lineage of that goes far back, right? I mean, the sort of post-Civil War change in the demographic of the Southern prison population kind of overnight was dramatic. The emergence of Black codes and the use of the penal system to create what David Blackman called slavery by another name. So there's a multi-decade connection between how the penal system has been used and the consequences of who it hurts most and who it hurts disproportionately. Which of course isn't to say that there's hundreds of thousands of white people in prison, because the system also massively hurts poor people. And there are poor people of every color. But it is the poverty that connects back to your resource point, because it is easier for a system to hurt people without resources when it's dependent on efficiency and sort of churning out the most convictions possible at the least amount of cost to the system. which is why defendants who have resources have a dramatically different experience going through the system. Just the fact that they have resources makes them sui generis, right? Because they're harder to prosecute. They have more that they can make it more costly. And they have a different type of experience with what the penal system is like. And if resources themselves are allocated based on sort of historical and ongoing racial disparities and systemic racism in a society, then yeah, you're going to see that racism impacts resources and then impacts how the system responds to people who don't have resources.
Thank you for
Thank
that.
you.
So, I think we're pretty much out of time. We've had a ton of engagement. I want to wrap up with just 2 closing comments. One is we had questions we didn't get to, including about, have there been examples of this outside of a movement context? What might a successful example of this look like? Which to me also relates to the question of somebody raised up, couldn't this be best, operationalized in the context of people who are factually innocent or among low-level misdemeanor cases? And I think those questions tee up for me the point you made really early on in the talk about how your own thinking about criminal punishment shifted in that class you took, and how this is really about an exercise in democracy, right? That this is about letting people who are under the boot of the state in this particular context exercise for themselves a kind of self-determination in thinking about what their rights are and how to assert them in a system that is finding creative ways to disincentivize people from accessing them all the time. So those questions about, could you have test cases that are the easiest cases, in some ways to me feels like in opposite to the bigger question of democratic engagement in the criminal punishment system, right? Which is often the people who are most activated are people facing the most serious charges because they are the ones who have the most at stake and who may in fact not be factually innocent in these cases and yet still deserve to stand on their rights, right? And that's the whole logic of public defense and of those great Warren Court cases you made. So I just wanted to throw that out there as a kind of closing frame for our audience in as you think about this concept and what it would take to make it real, that what do we lose by limiting it, even if I'm thinking about a test case, to only the most palatable kinds of examples. And with that, Andrew, I don't know if you have any additional closing comments, but we're so grateful you took all this time and extra time even. And we will be posting this for everyone's enjoyment and continued engagement, and as well as all the links we put in the chat throughout the event. And thank you all so much for staying on. And thank you, Andrew, for joining us.
Thank you. Thank you for having me, and thank you to your terrific audience. It was just such a pleasure to spend this time with you all. Thank you so much.
All right, everyone. Have a great night.